Welcome to the Supported Living Property Podcast with your host, me, Lisa Brown, the place to learn about supported living property investing. Hi Chris, it's great to have you here today. Thank you for joining us. How are you today?
Well, thanks very much for the invite, Lisa. I know you've been chasing me for a while. We've eventually got it together.
We've got it organised.
Very well, yes.
Do you want to introduce yourself and tell people a little bit about you?
Yeah, try and keep it as brief as possible. Got quite a long history. I'm a director of a residential children's home and an independent fostering agency. Through quite a long process. I've been a solicitor for about nearly 25 years now. And when I was at university, I was very lucky to get a temporary job at a children's home as a summer job going back into the early 90s, which gave me a great insight for that summer. And then I went back for 2 or 3 summers after that. Chance conversation with an old member of staff many years afterwards, after I'd set a law firm up with an old friend of mine in Darlington, sort of in the early 2000s, and asked, had I qualified as a solicitor. And we got chatting. He explained to me that he'd left local authority and had set up an independent children's home. And he rang me a few months later to say, following from that conversation, I'm thinking of expanding and would like to open a second home. You were talking about that you were developing a property portfolio as well as, with your legal business. Would you like to source some property? So in some ways, it's a classic little example of many of the people that you and I speak to over the years of how we came together and how people obviously are now coming together. So what happened is we had a series of meetings very early on a Friday morning, which used to be very exciting at a local hotel. For about 15 months or so, setting up a children's home is not easy. But John asked us whether or not eventually we would like to go into the business as well. So we'd done a lot of research on children's homes as well as the property investment, and we came together. He unfortunately had to pull out at the 11th hour of the transaction, but we decided we'd spent that much time. We decided to proceed with it, which was a huge leap of faith. And as many of your investors will know, and particularly your care clients, it's a lengthy process, it's expensive, and there's a huge degree of risk, as there always is with any of this, because you're not guaranteed you'll get Ofsted registration. So we did that in 2009. As a result of that and the team we started to build up, we expanded and developed an independent fostering agency around 2012. And as I explained, I'm actually sat in our training room and boardroom here. We went on to develop the property portfolio. I think we've got probably 10 properties now. And interesting point that with regards to our children's home, we are commercial tenants. We've got that ourselves on a long lease. But with regard to one of our other properties, we let that out to another children's home. So again, we've got a bit of an overview of both sides.
And that's why I've wanted to get you on, Chris, because I think it's quite unique in that you've kind of see supported living from so many different angles, don't you? You've got that legal experience, but you've also got your care experience, and you've also got the property experience. So all of that combined is really powerful. And I think,
as we said as well, we were invited by our local council here in Darlington about 2013-14, if I remember rightly. We actually took a leap of faith and we converted one of our properties, one minor conversions, into a supported living project. At that time, we didn't have any contracts, but all of the local authorities around us were very keen to come and talk. We invited everybody over, and Darlington decided that they wanted to pursue it further, but they had a slightly different model, and they offered us a 1-year pilot project, which I know we'll talk about. So we seized that and we developed our own supported living project for a year. So we've also had, as I say, experience of supported living as well as residential children's care. So
yeah, absolutely. And I mean, the key thing we're going to talk about today is about leases, isn't it? And about property investors and leases. And, as every time we've spoken on the phone, Chris, we end up speaking for far longer than we understand to, don't we? Because there's always so much to cover and chat about. But I think, it's about leases and what property investors really need to think about with those leases. So, should we jump into that and start talking about those things?
Absolutely. And as we've discussed before, Lisa, on many occasions, and I know I've spoken to a lot of property invested through the Facebook page, and we've had general conversations. And as I say, I'm a consultant solicitor nowadays, with a firm called Sweeney Miller in Newcastle and Sunderland. We have an excellent commercial property team. So I tend to introduce clients, give a lot of background to the law firm, and then they pick it up, and then we continue to speak as lawyers. But in general terms, yeah, there are many aspects, Lisa, that I've spoken to, investors around. If we're looking at it from an investor landlord perspective at this stage, key things I think is I always like to start out. Many people are experienced. They've obviously got experience of buy to let, as we all have, and they've decided they want to move on. A lot of people not maybe familiar with the care sector, and I think it's important to remember that the care sector, with regards to supported living, has many shades of grey. We've got experience with young people. I know many people out there who care providers maybe dealing with adults, which I don't have any experience of that. So it's always good to say to investors, you really need to be clear about if you've got a prospective tenant, what is their service specifically about? You need to do some due diligence. And one of the key things I always recommend, if they can, is speak to the prospective tenant and say, have you got a local authority contract behind you? Because from an investor's perspective, we're obviously concerned about the tenant's ability to pay the rent. We can get into general discussions about security from the tenant, which can be a deal breaker. I mentioned that. But if a local authority, if a care provider has obtained a contract from a local authority, they've maybe been part of a tendering process, one of the conversations I've had is to sort of remind investors that they may be very keen. I see it quite a lot. Oh, we're going to get a tenant into a 10-year lease. We want a 10-year lease. And that sounds brilliant, doesn't it? From an investor's perspective, for 10 years worth of rent, great, we can put that property to one side. There is, I think, a heads up, a warning here that typically a local authority contract typically won't be awarded for more than 4 years through a tendering process to a successful applicant under what they call a call-off arrangement. You have a general framework agreement where the local authority will approve you generally. Then if they call off your service, it's unlikely that that will be more than 4 years. So I've said to many investors, I'd be wary about granting a 10-year lease. What happens if that care provider doesn't get that contract renewed when it expires, and they knock on the door and say, sorry, we've lost our contract. We can't fund the rent for the next 6 years. Do we really want to get involved with litigation? These sorts of issues, which we all know, we've all had experience, very time consuming, can be quite stressful, and can also harm maybe relationships that you've got with your care tenant on other properties. So I would say, do some due diligence, ask your tenant if they're prepared to disclose that. If it's, for example, a charity and it's just intended to pay the rent off charitable donations, you may have an issue with the tenant's ability to pay the rent. So I think that's been a good point for a lot of people who said, oh, right, I'll go and ask that question now of my tenant, because that gives me, I mean, obviously you won't get the rent paid to you as a landlord directly from the local authority, but when that tenant has put its tender application in, it will have budgeted for that rent, or it should have budgeted for that lease rent. So at least the landlord knows, well, at face value, they should be able to cover that. And I'm quite happy. What we would I'd normally discuss then with a landlord is that you may, from your perspective, you may be approached, the tenant may want a break clause. And if I was advising a tenant, on many occasions say, if it's a new venture for you, you don't know how this business is going to go, your new care supported living venture, you may want a get out, an escape hatch. And from the conversations I've had over many years, I'd say to a client, well, realistically, if we're looking, say, at a 4-year lease, when do you think you're going to probably have a realistic view as to whether this is working or not? And if it's, say, a year, it's always a matter of commercial negotiation whether a landlord and tenant can agree this, and they may not. It could be a deal breaker, but maybe look for a break at a year, then you can get out. Because it's surprising, actually, I'm sure many landlords have experienced this, when you're dealing with tenants who have maybe got some familiarity with AST, in a commercial lease, they think they can simply serve notice on the landlord, a month's notice, and walk away. You have to explain it's different completely with commercial leases, that once that tenant's signed up, if they've not got a break clause, then And I'll use a simple example. If it's £10,000 a year rent and it's a 10-year lease, what the tenant's actually signed up is £100,000 liability, which comes as a shock. So the tenant may want a break clause at, say, a year to say, this isn't working for me for whatever reason. I'll serve notice on the landlord and I can get out. A landlord might be reluctant with that, thinking, well, I might only have this tenant for a year. I might want to increase my rent. Will the tenant pay that? What's their contract? If they've got the local authority, would it allow me to, really seriously increase that? You've also got to think as well, if you're a landlord, come across many occasions where a landlord may agree with a tenant to do certain adaptations to a property, and the landlord looks to cover that and wants to recover it through the rent. It's likely to be a disincentive, isn't it? If you think, well, if I grant this break clause at a year, for example, the tenant could walk away. So one of the other options which we've got in one of our leases is where the tenant asked for a shorter lease, but could we have an option to renew? So at that point, we'll know that if we successfully get our contract awarded, say from a local authority, again, the landlord and tenant serve a notice and we can renew the lease. That there are provisions where you might want to change some of the terms, but in principle, yes, the tenant can have the lease for another 3 years.
So it gives you that permission to renew the lease, like a priority over them. Does it stop them putting it back on the open market for rental? That option to lease?
Yeah, well, if the tenants, depending on the wording, but obviously, as I say, you would always speak to your solicitor about this and take further advice. But in essence, if the tenant has an option, if that's agreed, and the tenant exercises that option, the tenant then stays.
Right.
So the beauty to the landlord, I've got that tenant, great, if it's a good rent for another 3 years. Beauty to the tenant is it retains some flexibility to walk away if it doesn't get its local authority contract. And I've found that's been quite useful to speak to investors about that who had never really thought about that if they're new to this sector.
I think when you're a property investor and you're used to ASTs, and it's very kind of formulaic, isn't it, how an AST works? Yeah. And it's really straightforward, and that's how it is. And suddenly having to think about the world of leases, and they're much more open, aren't they? A commercial lease can be.
Well, when I've mentioned the 1954 Act, I always ask people, not that they expect them to be lawyers, but oh, what's that? And it is a key fundamental difference, because I know we talked about AST, and I've just touched on the fact that a tenant under an AST or a landlord can give notice, typically a month or 2 months, whatever, under the AST, and then walk away. It's entirely different with commercial leases. There's a lot more commitment for an unwary tenant. And one of the things which I would link to break clauses from a landlord's perspective, we were having that preliminary conversation, is I always ask commercial landlords, do you think you've got any intention that you might want this property back? And most people go, no, I want it let out for as long as I can possibly get it let out. I said, well, the reason I mention that is some people do. Some landlords might say, yes, actually, I'm happy to let this out for, say, 3 years, but I know in 4 years' time, for example, or 3.5 years' time, my business may need it. So what we can discuss, or the lawyers can discuss with the landlord at that point, which touches on a similar area of break clause, is what we call contracting the lease out of the 1954 Act. There are procedures around that, and again, you'd need advice on that with your solicitor, statutory declarations, etc. But what that does is that if the tenant is agreeable and negotiations continue, that allows the landlord to determine the lease when it finishes. Otherwise, the tenant has an automatic right to renew. Again, right. Procedures around that, people may be familiar with Section 25 and Section 26 notices without getting too deeply into it. But that is a potential option for an investor. They may not want a tenant in there for the longer period. So it's something we would always bring up to say, have a think about that. It might be, it may be useful. And the other thing
that needs putting in right at the beginning, Chris. So when you're signing that lease.
Well, to me, as I've explained to a number of people, I think it's vital here that people look at this and take potentially legal advice. They take accountancy and or tax advice. I do throw in there to people to consider whether you may want to, if possible, hold the investment through a SIP. And I know you've got people on the supported living, which is a brilliant, it really is if you can get that. But leases have tax consequences, as do break clauses, options, stamp duty, land taxes applicable, and it needs to be, considered. So would always suggest to any client, after we've had a preliminary conversation, please go and have a chat with your solicitor and your accountant if you think the lease is going to progress, and get early advice so you've got the best advice and you're prepared. I do see on the supported living page people occasionally saying, oh, has anybody got a supported living lease? And somebody goes, oh yes, I'll just send you it. And no, because whilst none of us want to pay big fees and maybe take the time, these things have a habit 2 or 3 years down the line, something crops up, we're digging that lease out of the, the dust off it from out of the drawer. I'm like, oh my God, why didn't I speak to a solicitor or an accountant at the time? So get early advice, prepare yourself as well as you can, and that minimises the risk of things going wrong. Yeah,
absolutely. And sometimes, with some of the bigger providers, you don't have the option to negotiate very much. They have a standard lease. This is what they do. So, and this is, you kind of have to accept their terms, because they don't have the ability to negotiate.
I had that conversation actually with another investor not so long ago, that in terms of commercial bargaining power, you may be in a very weak position. You'd be absolutely delighted if a big care provider, a PLC, come along. But as you rightly point out there, Lisa, quite often it'll be presented to you on a take it or leave it basis. The terms aren't negotiable, but it's almost that care provider saying, but the likes of us don't come along very often, and it could be a gold-plated investment. And that's one where you've just got to take a view and say, that might be just too good an opportunity, but yes, I'll sign up to the terms. But again, you would speak to your solicitor. And what we found in those instances, rather than negotiating clauses, what we'll do at Sweeney Miller is we'll say to a landlord in that instance, what we can do is report on the key terms for you. We can still recommend you get your accountancy and taxation advice, but if we do no more than report on key terms, because it's not negotiable, at least you know what you're signing up to.
Yeah. And that's really important, isn't it? I think that's I think that's the thing. I think it's very easy, as you've alluded to. Sometimes when we're talking to property investors, they're so excited that someone's interested in their property. They've got a provider. Oh, this is what I wanted. I'm really excited about it. They get a bit carried away without really thinking about the lease consequences. And yeah, it's very easy to sign something.
The type of people that are drawn to investing are quite go-ahead optimistic people. They're looking, to develop a business. So when you think you've got a real potential candidate as a tenant, naturally we want to get excited, and it's what we're all doing it for, with our investor heads on. But then you've got to calm down, haven't you, and say, look, I've been around the block a few times with STs. Commercial scenarios are no different. Let's just think great, and let's protect ourselves as investors. And also, to be fair with your tenants as well, I think if you're taking that approach, and I have spoken to a number of providers as well, you want to develop a good working relationship, because that care provider may come back and say, look, I'm expanding, I want to work with you again. And I know certainly on that property where we are landlords to another children's home, we've actually made contributions to repairs. It's something I wanted to speak to you about. Not because we had to legally, but we enjoy a really good relationship. And what it's actually done in terms of networking and growing, it's developed such a good relationship that children's home provider and ourselves, we're now looking actually to at a new joint venture project, because we've got on so well, which is going to benefit us both. Fantastic. So sometimes, you've got to look at the bigger picture, haven't you? And as I say, getting involved in legal disputes over leases is very expensive and time consuming.
I can imagine. What was it you wanted to talk about with repairs? Because obviously repairs are really crucial, and the wording around repairs in the lease is really important, isn't it?
Absolutely, yeah. Well, just in terms of, again, talking to somebody who hadn't appreciated that a couple of months ago, from a landlord's perspective, typically, you would retain responsibility for the roof, the structure, etc. But obviously, depending on the nature of the supported living project or care project, there could be potentially a lot of damage in that property. So from a landlord's perspective, you're looking to shift through the lease as much of the burden on the care tenant as you can. Most of the sophisticated tenants will be expecting that anyway, and they will take naturally care of their repairs. And from a landlord's perspective, you do have actually a couple of safeguards outside the lease that, if we're talking, for example, a residential children's home regulated by Ofsted. So if we take our children's home as an example, Ofsted are coming in there typically two times a year to do regulatory inspections. Repairs aren't really their issue, but the general condition of the property falls within regulation. And you'll also find typically as well that when we've talked, I know, about unregulated supported living projects, I have said to a few landlords there is an indirect element of safeguarding, because the local authorities, under their framework or service level agreements, they will go around and carry out the odd periodic inspection, and they'll ensure that the condition of the property should be suitable and obviously in accordance with the lease requirements of the tenant. So from that perspective, tenants' repairs also, I would anticipate, would be built into their repair cost if they've obtained a local authority contract. But from an investor's perspective, it can be quite a nice change if you've got a good quality commercial tenant who's picking up that repair cost, and it's not you picking up the phone to the plumber, the electrician.
That's one of the big appeals of supported living.
I had that. Oh, absolutely, it is. Yeah.
And I think the other thing is that they also often will organise the work as well. So, I know in some of my properties, even if it's something I'm responsible for, they will organise it, we'll talk about it, and then they'll bill it, because of the sensitivity of the tenants in the property. I can't just have any old person strolling in there on Thursday afternoon. Do you know what I mean? It has to be something. Yeah. So all of that actually means it becomes less of a headache as a landlord.
Yeah. And just again, I know we were saying that we weren't going to spend a lot of time talking about every clauses in leases, because as we know,
but they're important to understand.
Pages, they are, yeah. But on that point as well, always as a landlord, reserve the right to yourself in the lease to insure the property. You then insure it and you pass the invoice on to the tenant, because I have come across instances where it's the tenants, and if they don't, and the place burns down. So obviously always make sure when you're speaking to your solicitors, say, where possible, I want to retain the obligation. You'll put the relevant clauses in and then pass the cost on to the tenant. Again, the bigger, more sophisticated care providers will be very au fait with that. That won't be an issue to them.
That's a really important point, because then you can make sure it's covering the things that matter, that are important to you, and that you've got good quality insurance rather than the cheapest one.
Yeah.
Chris, have you got any hints or tips or advice for property investors?
I think really, just to recap, Lisa, what we've said is do your due diligence, try to minimise your risk. It is a risk area. I know some people sort of got into this area thinking, oh, manna from heaven, and but I think it's an area which is set to grow. We know there's potentially regulation coming in on the supported living, but for those investors that are treated seriously, take appropriate advice, and look to offer good quality property, then they're likely to get further knocks on the door off tenants, because they're looking to expand in their services as well, and build a healthy relationship. But you've got to do your due diligence. It's not something that I think people should just walk into and sign pieces of paper. Sit down, take your advice, keep in touch with the supported living, join the gateway, obviously, because there's a lot of good information sharing on there. And really, if you're part of that, there really shouldn't be you shouldn't really walk into any sort of a nightmare situation if you've done, as I say, the due diligence, and you can canvass opinion on the supported living Facebook page.
Chris, thank you. That help's been really, really helpful. It's been great chatting to you.
My pleasure, Lisa.
Thank you. Bye.